Welcome to the High Court Report. Today we dive into a case that sounds a little dry, but involves millions of dollars hanging on two little words, as of. This is the case called M&K Employee Solutions versus the Trustees of the IAM National Pension Fund. The Supreme Court will hear oral arguments on January 20th.
This case perfectly illustrates how Supreme Court decisions affect real money in the real world. 4 companies withdrew from a pension plan and suddenly owed millions more because an actuary changed some assumptions 3 weeks too late or 3 weeks too early, depending on how you read the law.
Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get nearly daily rundowns, and follow on YouTube to see shorts. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know. Let's start with the facts. Picture this. M&K Employee Solutions participates in a big pension fund with lots of other companies. When they decide to leave the fund at the end of 2017, they trigger something called withdrawal liability, basically their share of the fund's unfunded obligations to retirees.
Right, and here's where it gets interesting. The pension fund's actuary, the math expert who calculates these things, uses assumptions about future returns, mortality rates, and other factors to determine how much M&K owes. In November 2017, the actuary used a 7.5% discount rate assumption. But on January 24, 2018, 3 weeks after the December 31st measurement date, the actuary changed that assumption to 6.5%.
That tiny change tripled M&K's liability from $1.8 million to $6.2 million. We're talking about $4.4 million riding on when someone updates a spreadsheet. The other 3 companies in this case face similar massive increases.
So naturally, all 4 companies said, wait a minute, and went to arbitration, which federal law requires for these disputes. And here's the fascinating part. Every single arbitrator ruled in favor of the companies. They all said you can't use assumptions adopted after the measurement date.
The arbitrators relied on a Second Circuit case called Metz, which held that actuaries must determine assumptions as of the measurement date. Seems straightforward enough. If you're calculating liability as of December 31st, you need assumptions that existed on December 31st.
But then the pension fund trustees challenged these arbitration awards in federal court, and everything flipped. 2 different federal judges in D.C. vacated the awards and said actuaries can adopt assumptions after the measurement date as long as they only use information available on the measurement date.
Let's pause there because this creates a weird middle ground. The court said actuaries can wait until January to pick assumptions, but they have to pretend they don't know anything that happened after December 31st. It's like asking someone to make their best guess about tomorrow's weather, but prohibiting them from checking today's forecast. Exactly, and the D.C. Circuit affirmed this approach, creating a direct split with the Second Circuit's Metz decision. So now we have different rules in different parts of the country for the exact same type of calculation.
Let's break down the main arguments. The companies, the petitioners, make 3 primary points. First, they focus on the statutory text, ERISA. Section 1391 requires withdrawal liability calculations as of the measurement date. They argue this language creates a deadline, not just a reference point. Their second argument draws on legislative history and structure. When Congress created these withdrawal liability rules in 1980, they knew actuaries regularly made annual assumption reviews. The petitioners argue Congress expected actuaries to have current assumptions ready before any measurement date rolled around. Their third argument invokes anti-manipulation principles. ERISA. Section 1394 explicitly prohibits retroactive plan amendments that increase withdrawal liability. The petitioners argue this shows Congress worried about retroactive changes that hurt withdrawing employers, and actuarial assumptions should get the same protection.
The pension fund trustees, the respondents, push back hard on all 3 points. On statutory text, they argue as of establishes a reference date for calculations, not a completion deadline. They point to countless examples where valuations occur as of past dates using information learned later. Their second major argument centers on ERISA's requirement that assumptions reflect the actuary's best estimate of anticipated experience. They argue that forcing actuaries to use older assumptions when they have better information defeats the whole purpose of requiring professional judgment. And third, they emphasize that standard actuarial practice permits, even encourages, selecting assumptions after the measurement date. The Actuarial Standards Board explicitly approves considering post-measurement information. They argue ERISA should incorporate these professional norms.
The United States entered as amicus supporting the pension fund. The government makes three key arguments. First, they say ordinary language usage supports retrospective calculations. When you value something as of a past date, you naturally use all available information, not just information known on that date. The United States will participate in oral arguments as an amicus curiae, i.e., a friend of the court.
Second, the government notes that when Congress wanted timing restrictions on actuarial assumptions, it said so explicitly in other ERISA provisions. The fact that Section 1391 contains no such timing restriction suggests Congress intended flexibility.
Third, they argue existing protections already prevent manipulation. Actuaries face professional standards and statutory requirements to use their best judgment. The government suggests these safeguards make additional timing restrictions unnecessary and potentially counterproductive.
Now let's talk about why this matters beyond these four companies. The circuit split means companies face different withdrawal liability rules depending on where they operate. A company withdrawing from a plan in New York follows the Second Circuit's strict timing rule, while a company in California might benefit from more flexible timing under other circuits.
The dollar amounts highlight the real-world stakes. We're talking about millions in liability differences based purely on timing technicalities. And remember, this affects every multi-employer pension plan withdrawal across the country, construction, trucking, entertainment, you name it.
There's also a broader principle at stake about how courts should interpret technical statutes that intersect with professional practices. Should legal rules incorporate professional norms, or should statutory language override industry practice when they conflict?
The case also raises fascinating questions about the nature of actuarial work. The Supreme Court previously called actuarial practice more art than science, acknowledging multiple correct approaches exist. Yet this case asks courts to impose rigid timing requirements on this inherently flexible professional judgment. Looking at oral argument tea leaves and the court's recent ERISA decisions, prediction proves difficult. The conservative justices might favor the petitioner's textual argument about as-of language creating deadlines, but they also generally support arbitration awards, and every arbitrator ruled for the companies.
The liberal justices might sympathize with protecting worker pensions, which could favor the fund trustees, but they also tend to support professional expertise and regulatory flexibility, which could favor allowing actuaries discretion in timing. Justice Barrett's questions about professional standards could prove pivotal. She often focuses on how statutes interact with existing regulatory frameworks. Her view of whether ERISA should incorporate actuarial norms might swing the case.
Whatever the court decides, the ruling will clarify fundamental questions about timing, retroactivity, and professional judgment in pension law. Companies and pension funds nationwide will adjust their practices based on this decision.
The case also demonstrates how seemingly minor technical disputes can involve massive financial consequences. 3 weeks made a $4.4 million difference for M&K Employee Solutions, a stark reminder that precision matters enormously in pension calculations.
For practitioners, this case underscores the importance of understanding both legal requirements and professional standards. Actuaries, lawyers, and plan administrators all need to coordinate their timing and documentation practices.
The decision might also influence how Congress drafts future pension legislation. If the court finds the current language ambiguous, lawmakers might provide clearer timing requirements for actuarial assumptions in future amendments.
Finally, this case illustrates the complex intersection between federal law and professional expertise. Courts must balance legal certainty with professional flexibility, a challenge that extends well beyond pension law.
Bottom line, millions of dollars hang on whether, as of December 31st, means assumptions must exist by December 31st, or simply that calculations should reflect conditions as they existed on December 31st. The Supreme Court gets to make that multi-million-dollar call. Thanks for breaking down this technical but tremendously important case. For more analysis of Supreme Court cases affecting business and society, visit our website. Until next time, this has been the High Court Report. Thanks for listening, and remember, every Supreme Court case matters, even the ones that sound boring at first glance.